So welcome everyone to our 2024 Conn Maciel Carey Labor and Employment webinar series. We want to welcome you to this edition, which is New Employee Handbook Laws, Tips for Compliance. My name is Samuel Rose. I'm an associate in our Los Angeles office, and I support both the labor and employment and OSHA groups, representing clients in inspections, investigations, and enforcement actions, mostly with OSHA, but all over the country, and then also various employment issues, discrimination claims, wrongful termination, and drafting and reviewing employee handbooks. And I am joined by Mark Ishu.
Hello, everybody. My name is Mark Ishu. I've been with Conn Maciel for about a year and a half. Before that, I worked for the U.S. Department of Labor, Office of the Solicitor. I was there for over 10 years, representing various Department of Labor agencies, including the Wage and Hour Division, OSHA, EPSA, or Employment Benefits Security Administration. So I've been around labor for that period of time. In addition, before I joined the solicitor's office at the Department of Labor, I worked at the Illinois Attorney General, and I represented the Illinois Department of Labor in all actions, including enforcement. So I'm very excited today to be with you to pass on my knowledge, and Sam, I know, has a lot of background as well. So let's get started.
So on our agenda today, we're going to cover just some basic NLRB background, what it is, what it involves, how it works. And then we'll get into some recent NLRB decisions, post Stericycle, which is a case that we'll cover that kind of changed the analysis of employee handbooks. And then Mark will close us out by talking about just general issues to consider when auditing and reviewing your employee handbooks. So that's sort of the topics we'll cover. Hopefully we'll have enough time at the end for a couple questions. If not, then just put them in the chat and we'll be able to get individually. We'll submit responses to you guys after the webinar. So we'll start with some NLRB background. I'm sure most of you know that the NLRB, it basically acts as a quasi-judicial body in deciding administrative proceedings. The board generally consists of 5 members, which are appointed by the president. Currently, it only has 4 members. There's been a vacant seat for some amount of time now. And because the members are appointed by the president, the board typically reflects the ideology of and the platform of the White House. So whatever the president's platform is on labor issues, the board will tend to decide cases in that area. That makes it somewhat difficult for employers sometimes, because when administrations change, especially when we go from Republican to Democrat or Democrat to Republican, the NLRB can decide cases in a very different way, and so the pendulum is constantly swinging. So what we wanted to do here is kind of talk about the current makeup of the board, the current way that the board is deciding cases, and obviously with the caveat that this is an election year, and in November all of this could change going forward if the administration were to change. Also, just some general, handbook reasons to have a handbook. The handbook really has multiple functions. First is it is the first introduction for your employees to your organization. So when you're drafting your handbook, you always want to pay special attention to the tone that it's using. Sometimes people will put little introductory letters from high management or from the CEO to kind of make employees feel like they're welcome and that that the company is embracing them as a new hire. Also, of course, the handbook has policies and procedures. You want to make sure those policies and procedures are clear, that they're understandable by employees, and that, anything that an employee might need an answer to is included in that handbook. The biggest use from an employer standpoint is that they are often used in defense of legal claims. So when an employee makes a, discrimination, wrongful termination, failure to engage in the interactive process type claim, oftentimes us as defense attorneys can use your employee handbooks to kind of show plaintiff's counsel or the court that, your organization has policies and procedures in place on these issues. If the employee didn't follow the policies or violated the policies, then that's something that we can use in our defense of the claims as well. So employee handbooks are very important. You definitely want to have one. You want to constantly be auditing it, and we'll explain why auditing it is important, just to make sure that it is reflective of your organization's current structure, current policies, and also in compliance with the NLRB decisions. So let's get into these NLRB decisions and kind of talk about what's been going on in the last year or so at the NLRB related to handbooks. In 2023, the board issued its decision in a case called Stericycle, Inc. The citation is up there if anyone ever wanted to go on the NLRB's website. All these decisions are publicly available. You could just type in that citation to read the decision. Basically, this case revised the standard for the NLRB to assess whether an employer's work rules, especially in an employee handbook, unlawfully restrict employee activity. And it changed the standard to basically a presumption of unlawful if the rules have a reasonable tendency to chill employees from exercising their organizing rights or otherwise have a coercive meaning. And the case actually puts the burden on the employer to prove that it has a legitimate and substantial business interest that cannot be accomplished with a more narrowly tailored rule. Importantly, this case also kind of changed the analysis to be done from the perspective of the employee. So if the employee can't understand or it doesn't have a reasonable expectation for what the rule requires them to do, then that creates a presumption of an unlawful rule. So it really kind of places the burden on the employer to explain the rules, make sure they're clear, and takes sort of that analysis from the board's perspective. So there's been a couple decisions that we'll cover in this case that have come out post Stericycle, and this will just kind of give you all an explanation of the board's view on certain handbook policies and also sort of the way that it's analyzing cases with the current makeup of the board. So Sun Holdings, the employer had a confidentiality rule, and we'll cover a couple more confidentiality rules because there was a few cases involving those. In this case, the employer had a confidentiality rule that included information gained by the employees through working for the company that is not generally known, and it required the information to be kept confidential during and after employment. And it also prohibited employees from sharing that information amongst themselves. The union filed an unfair labor charge, and the case actually settled prior to going to the board. But in that settlement, the employer admitted that these confidentiality rules were unlawful. This isn't necessarily a board holding, so it's not necessarily, the board doesn't have to follow it. It's not precedential, but the fact that the employer admitted that these rules were unlawful kind of is a strong indication that the board indicated it probably would have found the same thing. In Harbor Freight and ExxonMobil, there were two other types of confidentiality rules that were at issue. In Harbor Freight, the board held that a confidentiality rule restricting the use of the employer's proprietary and confidential information was lawful. That's not a radical idea. We've sort of, it's trade secret, confidential material, all that stuff. At least post Stericycle, the board has found that though that type of analysis doesn't change, those types of rules are still lawful. The second rule was from ExxonMobil, and in that case, the confidentiality rule restricted employees from sharing information with each other regarding pension plans and other benefits, and the board held that that was unlawful because it was overly broad, and it restricted employees' ability to discuss terms and conditions of employment. So we can kind of differentiate that from the prior case, which is there they weren't allowed to discuss confidential information of the employer. Here they were restricted from discussing their benefits, which is a term and condition of employment. And so that was the differentiating factor for the board in finding that this policy was unlawful. In flow service partners, this case dealt with uniform rules and also the ability for employees to wear union insignia. So in this case, there were two employees who wore their union shirts instead of an employer provided company t-shirt or uniform. The employer had asked the employees to wear their uniform, but there was no rule in the employer handbook that required employees to wear a uniform. And the board held that the rule basically was unlawful because there was no handbook rule on point. It also referenced this special circumstance requirement, which is essentially that, you know, employees are allowed to wear uniform or union insignia on their clothing while they're at work, unless the employer can point to a special circumstance that would prohibit that. Basically, the moral of this case is that if you prohibit employees in any way from wearing their union's insignia, that rule is going to be deemed unlawful. It's just also another rule where this employer didn't have that rule in their employee handbook, and so the board likely used that as a reason why the rule was unlawful. In other words, even if you put it in your employee handbook, that's not gonna make it lawful if you're still violating the NLRB's rules. So captive audience meetings have been a big topic of conversation under this current NLRB board and also the current general counsel. Some background on captive audience meetings are that basically back in 1948, the board held that these types of meetings were lawful. And captive audience meetings are basically when the employer has employees attend a meeting in which the employer talks about reasons for rejecting union representation and sort of talking about the pros and cons of unionization. Later on in 2016, the board determined that, you know, these meetings, they are permitted, but they can't occur 24 hours prior to the NLRB mailing out the ballots for an election. And so they started to place some restrictions on it. The current general counsel back in 2022 made captive audience meetings a hallmark of her tenure as general counsel, and she issued a public memo that's on the NLRB's website basically saying that she thought that the captive audience meetings should be unlawful, that the 1948 case was wrongly decided, and that she was going to urge the board to overturn the 1948 case, which is called Babcock and Wilcox. So in this case, back in 2023, which involved Starbucks, a store manager had held one-on-one performance review meetings with employees to discuss their performance over the last year. And the store manager had discussed during those meetings potential consequences of unionization with each of those employees. During those meetings, the board found that the manager had actually asked permission of the employees to discuss this information, and they were also one-on-one. And so the board said that these were not considered captive audience meetings and basically ruled in favor of the employer. The general counsel has, in at least 4 cases since 2023, tried to get the board to overturn Babcock and Wilcox. To this date, in each of those cases, the board has refused to do so. That said, 2 of the members of the board have indicated that they, under the right circumstances and in the right case, would be willing to reevaluate Babcock and potentially deem captive audience meetings unlawful. So this is a very hot area of NLRB law right now. It hasn't changed much yet, but the potential is there for there to be a pretty big holding if the board decides to take a case where they overturn Babcock and make these types of meetings unlawful. In Harbor Freight Tools USA, the employer had a rule in its employee handbook that prohibited solicitation activities in working areas during working time, but allowed that activity during non-working time and in non-working areas. The rule did not specify whether this applied to solicitation during non-working time and in working areas. The union filed a unfair labor charge based on employees being disciplined for engaging in this activity during non-working time, but at the working areas. And the board basically held that because the handbook was silent on this issue, that the rule was unlawful. They were basically imposing a rule on employees that employees didn't have notice of, that wasn't included in the handbook. And it was more of an implied rule and not an affirmatively stated rule, which made it unlawful. So just another example, one, of reviewing your solicitation and distribution rules, but also just ensuring that all the rules in your employee handbook are explicit and clear and don't leave any ambiguity in what the rule applies to. In Phillips 66, the employer had a rule in its employee handbook that restricted the use of electronic devices to certain areas and for certain activities in the workplace. And that the use of cameras was really not permitted on most areas of the work site. The purpose of the rule was really for security and to prevent, dissemination of proprietary employer information. If employees were taking photos and that kind of information was out in public, then the employer has an interest in protecting that proprietary information. Two employees got in a dispute amongst themselves in the parking lot about their vehicles being parked improperly, and they both took photos of the vehicles, and the employees were disciplined as a result of that interaction between themselves. The union filed an unfair labor charge, and the board found that this rule was unlawful, that it basically restricted the employee's right to engage in concerted activity and could possibly chill their ability to engage in protected activity. So kind of a obscure, abstract rule, but if this applies to your workplace, just something to be aware of. So what do all these cases mean in practical terms? The case that we have cited here is from 1993. It's a general, it generally applies to handbooks, regardless of whether the NLRB is under a, more liberal or more conservative administration. But it's just really important that your handbooks clearly state the purpose of any policy, that it identifies specific activities that are prohibited, that you consider using disclaimers of what activities are not prohibited so that it's clear to employees and also to the NLRB if your handbook ever comes under scrutiny by the board, and that you consistently implement and enforce the policy so that the union doesn't have any claim that you're not implementing or enforcing the policy equally amongst all employees. And this is just some general advice that should apply to your handbook, no matter what the current state of the board is. So based on these cases and based on, just the way that handbooks are scrutinized these days, it's really important that employers review, audit, and sometimes redraft the policies that are included in some of their handbooks. And that would apply to most policies included. I mean, the EEO policies, anti-harassment, discrimination policies tend to be a little more, those tend to not change as much, assuming the state that you're operating in doesn't pass laws broadening or restricting the groups that are protected under those policies. But if you have social media policies, if you have civility rules, ruled restricting the use of email, Slack, messaging, confidentiality rules, all these types of rules that are more, not typical in an employee handbook, but that are still important. You'll definitely want to make sure that these policies are clear, that they're enforced equally amongst all employees, and that, if there's been any decisions by the board impacting these types of policies, that you are using those decisions to craft the new policy. So that's a little bit about the NLRB decisions post Stericycle and how the NLRB works. And I will turn it over to Mark to discuss just additional issues relating to employee handbooks outside of the NLRB's decisions.
Thanks, Sam. Yeah, so as Sam mentioned, we're dealing with a new era. Post Stericycle, has you examining all the things that Sam mentioned in his slides. But even further, it's a great opportunity to evaluate all your policies and procedures, all your practices, especially if you believe that there's some issues that are not working well. If your EEO statement may not be in line with the current status of what kind of company you want to be from a DEI perspective, it's a time to revisit that. It's a great opportunity to look at everything. And so, I want to just say that from a discrimination standpoint, you should have a policy laid out. You should state that, discrimination is that's based on race, color, religion, sex, pregnancy, sexual orientation, gender identity, national origin, disability, and age is illegal and it will not be tolerated. Again, this is a great place to point out, what your company is all about and why you're following what the current law is. You should also provide reasonable accommodations and to applicants and employees. You should lay that out in your employee manual for either medical reasons or religious reasons. You should explain how employees can report discrimination and how exactly they need to report it. If possible, in your employee manual, you should designate more than one person to receive and respond to any discrimination complaints or questions. You should consider permitting employees to report discrimination to any manager. State there clearly that employees will not be punished for reporting discrimination, participating in any discrimination investigation or lawsuit. You should state that you will protect the confidentiality of employees who report discrimination or participate in an investigation. You should require managers and other employees with human resource responsibilities to respond appropriately to discrimination or report it if it's seen by those individuals. You should give them authorization to respond as well. You should provide for prompt, thorough, and impartial investigations. You should lay that out, kind of the steps and how and why it's going to be impartial. You should provide for prompt and effective corrective and preventive action. You should consider requiring that employees who file internal complaints be notified about the status of their complaint, the results of the investigation, and you should describe the consequences of violating the non-discrimination policy, either termination or suspension, etc. You should, again, this is a great opportunity to reevaluate all your policies and procedures. If you haven't written a handbook for your small company, or if you have already a handbook, this is again an opportunity to not only be aligned with the Stericycle decision, but also in line with all law that's ever changing, including the EEO in the EEO context. Another aspect that you should look at is as I lay out here, is your harassment policy. You should identify similarly that there's no tolerance for any types of harassments, and you could report harassment and how you need to spell out exactly how to do so. And you should lay it out similar to the way in which they're reporting discrimination. So there's no misunderstanding as to one way or the other. because they do overlap. And you should do the same things: protect confidentiality, not punish, and to make sure that managers and employees understand their responsibilities and their job description, and to specifically how to respond appropriately to harassment. You should again have investigations and the like, similar again to the way it was laid out or I discussed earlier. Also as basic as as it is, you should have some statement and acknowledgement of at-will employment just right off the bat in your employee manual. And finally, you need to have an opportunity for people to understand these rules. So don't forget that you need an acknowledgement. And if an employee doesn't understand these things or claims that they weren't clear in the workplace, at least you have a signature from that individual identifying that they read and understood all the policies and procedures of your company. Next slide, please. Here's a policy, just an example. Please understand, don't take this and put this directly into your employee manual, but it just kind of lays out how important it is to specify, and how now this NLRB is kind of approaching all the cases that it sees. You need to be clear as much as possible, and this will give you this first kind of policy laid out here on the slide will give you kind of a start. You should probably consult an attorney to lay it out as effectively as it possible in all the permutations. But I think this gives you kind of a sense of how much specificity you need in your policy statement regarding the restrictions on employees, and specifically the NLRA rights that they have. I discourage writing policies similar to what is described below, because this current NLRB is not going to give you credit for a very general statement. They want you to provide, as Sam said, provide examples, so there's no confusion as to the interpretation of the policy. And so you want to make sure that it's as explicit as possible. You state it 4 or 5 times, and all the different variations that a human could consider and understand, so they get it right. And so this is just to kind of lay out the way you need to think when you discuss your disclaimer of restrictions on employee rights. Next slide. So here we have, employee discipline is another thing that you need to be very careful with post Stericycle. As I lay out here, the board reverted to its pre-2020 setting specific standards for determining whether an employer lawfully disciplines an employee for otherwise protected concerted activity. I'm specifically referencing the Line Elastomers LLC case. You can see the site there, but it's really a four-point test, and it follows what, if you're familiar with NLRB, the Atlantic steel factors, which historically, pre the current board have been in place, pre the Trump administration, I should say, had been in place. The first thing to think about is the place of discussion. The second thing to consider is the subject matter of the discussion. The third thing is the nature of the employee outburst and whether the outburst was in any way provoked by an employer's unfair labor practice. In that Atlantic Steel case, it really came down to whether or not the statements that an employee made were justified them being terminated. And so that kind of framework evolved, and that's what you have in the Line Elastomers case. So you're really looking at the locus of the activity, the subject matter, whether it was protected conduct, the nature of the employee's outburst, and if the outburst was provoked by employees in the employer's manual. So ultimately, you need to think about this in discipline always in this context. Now, discipline could be related to something that someone said, like I'm explaining now, but it could also be just conduct, inappropriate conduct. And so you need to analyze it with these 4 factors in mind. So if you create a rule that specifically may lead to discipline or termination, you need to think about these 4 factors and whether or not that individual has some form of protections under the NLRB law, and to make sure that it's clear enough in your policy manual such that these 4 factors are addressed. And sometimes you need to provide examples to do that. So ultimately, this decision and post-steri cycle grants greater latitude to employees who are overzealous or even abusive in exercising what would otherwise be activity protected by the NLRB and by the Act. A policy that prohibits insubordination should likely be revised to identify examples of conduct that the rule is intended to address and not address. Again, the more specific you are, I can't stress enough, the better you're going to be under this post-steri cycle context. Next slide. Another thing to look at and audit internally, and your manual is a great place to lay it all out. It's like the instruction manual for anything you're doing, so employees are not confused, is that whether or not employees are exempt or non-exempt. Some of you may have employees that are paid hourly, and so they're, if they work over 40 hours, they are due time and a half, and you want to make sure you're clear about that policy so that there's no confusion of whether or not someone qualifies for being paid time and a half, or if someone's exempt from being paid time and a half. So I just want to point out this is a good opportunity to audit your company's way of paying employees, and what better place to start doing that than your employee manual. And for those that don't know, in April of this year, the U.S. Department of Labor released a rule amending what white-collar positions qualify as exempt under the Fair Labor Standards Act. So another reason to reevaluate this. There's laws changing, and now there's a new rule that raised the salary threshold for overtime exemptions titled, you could look it up online, defining and delimiting the exemption for executive, administrative, professional, outside sales, and computer employees. There's also some recent guidance regarding who should be classified as an independent contractor versus employees. And I'll get into that also a little later. A violation of these classification standards can certainly subject you to employer liability. So what better way to lay it out so that that does not happen? It's the instruction manual for the company, the employee handbook. So you could address these issues so that you have a better disposition, as Sam said, in litigation. Next slide. So here's just a little background on exempt, non-exempt. I'm not going to go into it too much in detail, but I just want to give you a kind of a flavor for those that don't know. There's an exemption here from the FLSA's or Fair Labor Standards Act overtime pay requirements, and specifically that there's a test that you need to look at to determine whether you're exempt. You look at the salary basis test, and that's basically employee being paid a specific salary. It has to have the employee has to pay a predetermined and fixed amount that is not subject to the reduction because of variations in the quality or quantity of work performed. So that's something that they call the salary basis test. There are also regulations at the Department of Labor that discuss the salary level of that basis. I'm going to go into that. That's what's changed. And there's also a duties test. Again, duties must primarily involve, the type of things that you would expect for the professionals in question. And I'm not going to go too much into the test, but, again, that's for another seminar, but you should be aware that there's some changes here. And now there is a less there has been a less restrictive duties test for highly compensated employees. And we'll talk more about what that is as it's changed now, what highly compensated means. So the bottom line is that, the Department of Labor's new rules significantly increased the salary level basis thresholds for the executive, administrative, and professional workers exemption and the highly compensated employees. And this slide lays out the new, the changes. In order to make sure employees are exempt and maintain that exemption, you need to now pay them more money. In July, July is around the corner. July 2024 is when it first kicks in here. This new rule that the department put into effect. And that increased from, as you can see, from $684 per week to now $844 per week. So if you're not paying them $844 per week and you thought they were exempt under this, the professional exemption, et cetera, then, you're going to be violating the law. So again, a great opportunity to look at your employee manual and to make sure your employee manual lays out the details as to how to pay employees. It's going to increase next year as well. So, you'll be on guard to make sure you do something about it next year. Now that now, the highly compensated employee exemption also changed. Again, the duties test changes when you pay a certain threshold amount. It's gone from 107 to 132 and some change. And so you should make sure employees are paid properly in that respect. Otherwise, you could be subject to wage and hour lawsuits under the Fair Labor Standards Act. Next slide, please. As I mentioned, the independent contractor rule went into effect recently as well. The department, changed its approach to how to determine whether or not employees are considered exempt, or considered independent contractors or employees. Be aware that you should consider that again when you're looking at your employee manual. If there is issues on this, normally people have employees, but if there are situations where there aren't employees or there are sometimes independent contractors, you need to make sure that it's clear that, these factors are considered before making that determination. The opportunity for profit or loss, the investments by the worker, permanence of the work relationship, nature and degree of control, whether the work performed is integral, et cetera, skill and initiative. So think about that as you write your employee manual or you audit and revise. Next slide. Now, as we all know, COVID changed everything, for better or for worse. Some people think for better, some people think for worse. But you absolutely have to make sure you're on top of the policy, your remote work policy, to address this new world that we're living. Again, and now you have that opportunity. So you should make sure you update your policy, and especially when things are not working out the way they're supposed to. This is again an opportunity for you to kind of look back, look at the company and how it's operating and what's working, what's not. But yeah, as we know, because there's so much more room now to have employees work remotely, there's a lot of moonlighting, and the location of an employee is important. Because it determines the law that applies to them, even from a tax standpoint. So you need to delineate in your policy what's allowed, what's not allowed, to ensure that they're, if employees are working 2 jobs at once, obviously you don't, that's probably a violation of your company's policy. So you need to make sure it's clear what they're expected to do when they're remote and why they can't do that. You have to prohibit it, right? So you should lay that specifically out. Again, this post-stericycle world, you need to explain things much more than you did previously. But again, you need to delineate what an employee needs to inform you when they decide to move. If they decide to move, they have to identify where they're moving in advance, so you know how to pay them properly under the tax law of the state. What laws apply, because state laws, we're going to get into, is different on a lot of fronts when it comes to leave, for example, and what employers are required to do in granting leave to employees. So you really do need to have a policy in effect that identifies exactly what an employee is supposed to do if they decide to move to another state. as well as the prohibitions of what remote work is all about. Next slide, please. So as I mentioned, employee leave policies are something you should be examining as well. The sick leave, the paid time off policy, holiday, parental leave, FMLA, bereavement. Each state really does have its own way of approaching these things outside the federal context. Certainly the FMLA or well, the bottom line is you have a lot of things to consider, both state and federally, when you're looking at leave. And, for example, I practice a lot in Illinois, and I will tell you there are several laws in Illinois that identify what employees are supposed to do, and what employers are supposed to do when it comes to leave. For example, the Family Bereavement Leave Act in Illinois specifically, lays out how an employee is supposed to inform their employer about taking bereavement leave, what is allowed under the law, and specifically what an employee is entitled to when it comes to bereavement. They talk, detail as to in the statute about what a covered family member is, and so you need to lay that out in your employee manual. You shouldn't just refer to the law in the state applies. You should say, in Illinois it applies this way, in Massachusetts it applies this way. You should specify as much detail as possible as to how the Family Bereavement Leave Act applies, or whether or not the process in which an employee has to take under that law. There's just to be more clear what I'm saying, in Illinois there's also the Employee Sick Leave Act. It requires specific amount of time that is you need to provide your employees with specific amount of time when they're sick. There's the Paid Leave for All Workers Act, which also allows, it's the Paid Leave for All Workers Act in Illinois allows workers to earn up to 40 hours of paid leave from work each year, and that's mandatory. And so you need to have that laid out in your manual. And again, I'm going to stress this over and over again. If you don't lay it out in your manual, there's a possibility that managers or people who make decisions as to whether or not an employee could go on leave will get it wrong. So you need to tell them, you need to be clear as possible that, how it is that they need to allow their employees or allow your employees to take leave. There's even the 1-Day Rest in 7 Act, which requires employers to provide employees a minimum of 24 hours of rest within every consecutive 7-day period. Again, all these statutes I'm mentioning are in Illinois. Every state is different. Some states have some of the things I'm mentioning, some states don't. So you need to check your state law on all these different things to determine whether or not you are following the law, essentially, and you need to lay it out in your manual. Next slide, please. There are, other policies to consider revising. The Pregnant and Lactating Employees Act is important. I'm sorry, the Pregnant Workers Fairness Act is important, and the Pump Act, specifically for pregnant and lactating employees. You have to lay that out in your policy to make sure you don't have any managers are not adhering to what the law requires. There's the Crown Act. Approximately 24 states have enacted legislation that prohibits race-based hair discrimination in the workplace. And I think ultimately, actually what I read the other day was this Crown Act has also been recently, it was passed by the Democrats in 2022 in the House, I should say, and it died in the Senate, but it was reintroduced very recently, I think last month, in the House. And I don't know if it's going to become a law, but it's something to think about now. If your state doesn't even have a rule on the Crown Act or legislation passed on the Crown Act. Cannabis and drug testing, state laws are increasingly passing legislation legalizing marijuana. Does this mean no more drug testing or for cannabis? Well, I think it depends. I think someone asked a question in the chat about, let me just double check, but I think someone asked a question relating to the CDL drivers. Well, that was on the exemption, and we certainly could answer that. But I want to first discuss the cannabis and drug testing. The CDL is a federal license. So it's a federal related license, I should say. It's pursuant to federal law as well as state law. So you need to be careful here, because there may not be a basis for you to say, that, oh, because it's legal in the state, everyone, we can't test for cannabis. That license may require it, right? So it may apply, it may not, but you need to think about these things and consult an attorney on whether or not your state, is one way or the other, and how you should lay out specifically your employee manual. Artificial intelligence, when we're dealing with artificial intelligence, it's great, it's helpful. You could use it for many things to make your job more efficient, but in the hiring context or the promotion context, there could be a lot of legal issues that come up when you use it. And we even have another webinar that talks about that. So, I'm not going to go into detail there, but something to definitely flag. Pay transparency and equal pay. When we're talking about these things, you need to be careful, because in some states you're required to identify all your employees' pay publicly, and in some states you don't need to. So that manual policy needs to lay that out, and it's also another opportunity to reevaluate all your employees in the pay disparities, so to make sure that you correct them before that disclosure is required under the state law. But there's also certain laws that in certain states that identify that you can ask about their previous wages. So you need to keep that in mind. And again, what better place to lay this all out than your employee manual? It's the roadmap for everyone's thought process when it hires, when it fires, and when it conducts business with employees. So, I did talk about harassment policies already, as well as the EEO in the EEO context. Just again, make sure you have a policy put in place and it's delineated in your employee manual. Non-competes. A lot of people are talking about non-competes. The law is changing in each state as to whether it's prohibited or not in whatever context. The one thing you don't have to worry about is you don't need to lay that likely out in your manual, but consult an attorney to make sure it applies in the state that your company is in. Let's see here. So I think that's about it. I know that there's been a lot of questions in the chat, and certainly ask more questions. We don't have too much time. I don't know if we can answer all of them, but try to answer some of them at least. And if we don't answer your question, we will be happy to, again, follow up with you later on to answer it, to make sure we answer it. Lynn said earlier, what does it mean to chill employees? I don't know, Sam, do you want to answer that, or I could follow up your call?
Yeah, I think that was in relation to the NLRB's decision about, whether handbook policies tend to chill employee exercising their rights. Chilling employees is just a term that the NLRB uses when employers engage in unlawful activity that tends to prevent employees or unions from exercising their rights under the NLRA. So that could be anything from, threats or coercion or policies in the handbook that violate their rights under the NLRA. It's really just a broad term for any type of unlawful activity by an employer related to the NLRA.
Yeah, and I'll just add to that, again, now you want to be as specific as possible, but you don't want to confuse anyway so that they are chilled. So I think the best way of thinking about how to consider revamping or auditing your manual is to, obviously it's always wise to consult an attorney if you're confused about a certain provision, whether or not you believe it chills employees. But, there's ways to vet these things carefully instead of just, assuming. You should spend time to have a committee put in place, management committee that thinks about all these things in detail before, rolling out your policy, so that there's no confusion as to whether or not there is a chilling effect. You need that various perspectives kind of sitting in a room to think about it before you can make that conclusion.
I'll just make one more point on that, Mark. We've been covering this whole webinar has been from an NLRB perspective, and Mark touched on state law a little bit during his presentation, but it's a very nuanced and delicate balance when you're dealing with an employee handbook, because that employee handbook needs to be compliant with NLRB law, but it also needs to be compliant with state law. And so if there's certain leave or sick leaves, family leave, any type of state specific policy that your state requires in the different areas where your company has operations, you need to make sure that those notice requirements or those policies are also included in the handbook. And so it becomes it can be sometimes a very complex balancing act with what gets included in the handbook, what doesn't get included in the handbook, and what is required to be in there versus what you might choose to leave out. And that's where, we or an attorney that understands labor and employment can help you deal with that balance and ensure that your handbook is compliant with both state law and NLRB law.
Yeah, I mean, I know that we're a broken record here. You definitely need to consider that when we're putting this, putting your manual together, when you're making decisions as to whether or not someone's exempt or not. You need to consult an attorney, and you need to provide that attorney with all the facts so that they have a basis to fully, evaluate the issue. Of course, they're going to ask you a lot of questions before making a legal determination. And in line of that, the next question is, are CDL drivers allowed to be classified as exempt? What is required in Illinois? I need to have more facts. There may be a basis to say they're exempt, but it depends on, as I described earlier, some of the thresholds that we talked about, as well as the duties. Depends on what they're doing. If it's just like a moment that they're using their CDL, if they're doing small tasks with it versus like that's all they do. There's a lot to talk about here. Lynn, you certainly could reach out to us if you have a specific question about kind of a certain set of employees that are in your company. Can you include sick leave into the PTO rather than have separate policies? So again, each state is different on this. So we'd have to know whether or not the state allows you to do that. In Illinois, again, there's a requirement to kind of have sick leave a certain way, as well as vacation or PTO. You just need to make sure you follow the law from the state and that the employee manual reflects that. Again, I want to stress, the remote work confuses things, because if you have 5 employees that are also in another state, that another state law applies. So you need to spell that out in the employee manual that, if you're in this state, this is, your sick leave policy versus that state. So it's become much more complicated because of, a lot of people are working remotely in other states. But again, the more the reason to have a very clear policy that they're required to notify you when they move. Otherwise, how are you going to know? They may not tell you, and And then next thing you know, they're in a state that requires much more rigid employer requirements and leave requirements specifically. So you have a next question. Does Illinois Paid Leave for All Workers Act add one more leave week to your vacation PTO? Let's see if I understand that question. Does Illinois Paid? So the act itself, it lays out exactly what an employee's excuse me, entitled to. So you need to meet that minimum requirement. If you're confused on this though, I'd like to talk to you more about it to see and fully understand your question, but the actual act spells out the specific requirements and how much PTO is required for an employee working a certain amount of time at your company. I could just bear with me here. So, again, it requires workers or requires employers to provide employees 1 week of PTO or 1 week of vacation. And workers can use it for any reason. And employers may not require workers to provide a basis for their time off request. That's a very important point because you need to lay that specifically out so your managers understand that, they're not required to provide a basis. Because if you have a manager that's upset with an employee thinking that they're, saying that they're sick when they're not, that could be a problem. It could be held under the act and there are penalties associated with that. But workers under the act earn 1 hour of paid leave for every 40 hours they work. Okay, so that's the way in which it's calculated. Again, it's important to consult an attorney. There are certain exceptions that apply if you have an existing policy. I don't want to go too much into it at this stage, but and there's also certain categories of workers that are not at all subject to this law. So you need to consult an attorney, or you need to look up the law. You need to be versed in what the law requires.
So it's just about 11. So we'll start to wrap up. This is the rest of the schedule for this year in our 2024 employment webinar series. So the next webinar will be July 25th, and it will be our mid-year California labor and employment law update. Lots of stuff going on in the California legislature this year. So if you have operations in California, you'll definitely want to be sure to tune in for that webinar. And then we also have our OSHA blog, Employer Defense Report blog, Cal OSHA blog, and MSHA blog. All of these blogs are updated periodically. Some of them are weekly. So if there's a hot button issue being covered in any of these areas of the law, it'll be covered on our blog, and you can feel free to log on and read the blog articles and reach out if you have any questions on anything that we post there. I want to thank everyone for joining us, and feel free to reach out if you have any questions. All of our contact information is on our website, and we'll see you next month. Thanks, everyone.